I would like to thank everyone for coming tonight, more importantly the students. And those of you in the audience, I think you're going to miss a really good interaction, but we're glad that you're going to be watching us on the internet. It's the Exchange Club's privilege to present a program on the U.S. Constitution and the First Amendment. We feel very privileged in having these two exquisite speakers, and it's Cheryl Cook-Kallio, who is involved in iCivics by Sandra Day O'Connor, and John Murphy, who is a recently retired attorney from the California Supreme Court. So will everyone please join me in thanking them for coming here tonight and informing and educating us on really what our First Amendment rights are and how we can protect them. Thank you.
You know, I thought we'd start out a little bit and tell you all, you know, who we are. I mean, that was a wonderful introduction. I really appreciate that, Donna. I am a teacher. I've been an elected official. I'm an AP US history teacher in Fremont, and I teach AP government, and I do a lot of work with civics nationally. So I will talk to you a little bit about how we'd like to see the essay written and about the First Amendment, and I'll let you introduce yourself too.
Oh, I have one.
Okay.
I have my own. My name, as Donna mentioned, is John Murphy. I'm an attorney. Been an attorney longer than I care to say now. Sort of a checkered background. I've spent 11 years in various forms of private practice, but I spent more than 30 years in the federal and state government. Most of that was as a senior attorney in the California Supreme Court for almost 30 years. And there, obviously, we dealt with lots of constitutional issues, including a number of First Amendment issues.
Okay, so I'm going to start out a little bit by telling you about this essay, and I'm sure you've all read about it because that's why you're here. First of all, it's an essay that I think carries a wonderful reward, but the real reward is what you're going to do with the information when you're adults, and it's about the First Amendment. I would assume that you all have read the First Amendment. Do you know, if I asked you, could you tell me the 5 freedoms of the First Amendment? If you just think about that, I'm not going to put you on the spot. But I want you to know that only 3% of Americans can do that. That's an amazing thing. Only 3% of Americans can talk about the 5 freedoms and the First Amendment. And so you have the question here, and what we would like to know is what you think about this. Not what somebody else has said, but what you think about it. It's really important that you follow the directions and that you adhere to all the criteria here that are on this sheet of paper. Do you all have a copy of this yet? Okay. So the question is very easy. Have you read it yet? Okay. What it says is, do you believe First Amendment rights are absolute? Under what circumstances, if any, should First Amendment rights be limited? Which of the 5 freedoms listed in the First Amendment do you believe is the most important, and why? I kind of was chuckling when I told you it was very easy, because as my colleague will tell you later on, it's really not. All courts have argued about these things since we've been a country. So it's not easy. There is no right answer. So you're not going to do research someplace and find this is the answer to this. Lawyers, judges, they argue about this all the time. Also, you need to narrow. You only have 500 to 750 words. So you need to narrow this down and talk about something that's important to you. Okay, so can anybody tell me the 5 freedoms of the First Amendment?
Speech, press, religion, petition, and assembly.
Excellent, excellent. We have one of the 3% here. That's that's awesome. And then when we were talking about this, sometimes people will look at the First Amendment and they'll see religion in 2 parts, and that is the Establishment Clause and the Free Exercise Clause. How you all choose to deal with that is up to you. I would guess that you would like me to go through the directions on the essay. So it's eligible, and students in grades 9 through 12 are eligible. So 9th, 10th, 11th, 12th grade. The first place scholarship is $1,500, second place is $1,000, and third place is $500. And then you also get to call yourself the scholarship champion for this.
Bragging rights.
Yes, bragging rights, exactly. So the topic of the essay is for you to demonstrate your understanding, but again, I want to emphasize it's what you think about what you've read. It's not what somebody else has said. You need to either watch this videotape or you need to be here, so thank you all for coming, because of course we couldn't do this if you weren't here. You need to possibly use some of the information that we have given you, but whatever information that you use in the essay, you need to provide some kind of evidence. So we don't want it just to be your opinion. It should be your opinion based on fact. And I'm sure you've had training in that in school in terms of how to write an essay based on evidence. And I would encourage you, if you have questions about that sort of thing, to make sure that you ask. And even at this forum, when we quit talking, you can ask those kind of questions. You can use the information in this booklet that you were given, as evidence. You certainly could use this as evidence also. I think that's also contained in the booklet. You need to make sure that you have this in electronically by April 17th, 3:30 p.m. Now, the advice that all your teachers would give you is do not wait till the last minute, because you know how computers can be, right? Mine always goes down right before something's due. The word count is 500 to 700 words, which is not a very long essay. It's probably 3 to 3.5 pages, double-spaced. Size 12, single-spaced. Well, if it's a single-spaced essay, it's going to be less. It's probably going to be more like 2.5. They want a line between each paragraph. This is to make it easy for us to read. You need to quote if it's a direct quote, but I think you also need to cite if it's a paraphrase. We want to make sure that we know where you get the information. And if you don't know the difference about that, that's one of the questions you could ask later. You need to make sure you have a cover sheet and that you sign that this is your own work. And if you have any questions at all, Donna Kerger's address, email address, and phone number is written here for you. Okay, and I also want to make sure everybody gets one of these. So everybody should have a pocket constitution. Certainly.
I'm Karen Stepper and Richard Price, the former president, current president of the Exchange Club. This is our 9th year. We've given out over 25,000 in scholarships. So we're excited that you're here, and especially the speakers that are here. But for students who come from San Ramon High and Cal High, you have all had winners from your school for this scholarship program. So we're looking forward to reading it, and it is a blind graded essay. Thank you.
Go ahead.
Yeah, I just want to expand on something that Cheryl mentioned. The First Amendment is very complicated, very complex. There are 9 members of the United States Supreme Court, and when they decide First Amendment cases, it's almost never 9-0. Some of the largest First Amendment cases had no majority. They had very split decisions. The type of thing you'll be looking at, if you're looking for the answer, you probably will not find it. These things can become very subtle and very difficult, and I think the important part is to think about the concepts and the ideas behind it, which ultimately the First Amendment is the foundation of American individual freedom and rights. Think about the concepts, the conflicts, and the reasoning of why one thing would go one way or the other. And as I mentioned, there are 9 Supreme Court justices, and they rarely are unanimous in a decision about the First Amendment. So, my suggestion to the students is don't approach this with the idea that you're going to come up with an answer that everybody agrees with. It doesn't happen.
So I think part of your job is to convince us that your assessment is a valid one. And one of the ways I would tell students of mine to do this is I would ask, which of the 5 do you think are most important to you? Which one do you think that you would fight to the end to make sure that you could protect? And that, I would think I would start there. For some people, it might be freedom of speech. For some, it may be freedom of religion. Certainly, to petition is to talk to your government. How important is that? To be able to assemble with people of your choosing, that's important. The press, does the press check the government? All of those things are viable, but I think what I would do if I were you is I would think about them and maybe think of examples that come to mind about times when that has been in conflict, and then start from there. You don't have to write on all 5 freedoms.
Yeah, I can tell you, there is a 12-volume treatise in the law libraries on just the First Amendment. So if you were trying to write on all 5, you're going to find out that's a real undertaking, and with the limits you have, you probably couldn't do justice to the various rights if you tried to do all 5.
I think also, do any of you have it memorized? Could you tell me what the first line of the First Amendment is? First few words. It says, Congress shall make no law. So it's what's called a negative right. It means the government cannot prevent you from doing this. A positive right would be something like you have the right to marry, but Congress shall make no law. And so in that sense, it limits the government's power over you, and I think that's an important thing to remember. I think it's also important for you all to know that if you have a question, please ask us, because that's going to be very helpful to the people watching this tape, is that they hear questions that would normally come out of this discussion.
Yeah, you'll notice it says Congress shall make no law. Congress is the federal government. So you may ask, well, what if the California legislature or the San Ramon City Council makes a law that infringes or violates one of these rights? Are they exempt from the First Amendment? No. The short answer, I'll give you the short answer. The United States Supreme Court held quite a while ago that the First Amendment is incorporated through the 14th Amendment, which does apply to the states and local governments, and is just as binding in every respect on local and state governments as it is on the federal government.
Do you all have any questions? Okay, so I think also a piece of advice that I would give you is to try to think of something personal. Is there a time in your life where your First Amendment rights have been abridged? Are they absolute? Can you say, for example, can you say anything at school? Do you know why?
Teachers won't let them.
Well, students do have rights at school, but they're abridged to a certain degree because you're considered under the tutelage of the teachers. It's called in loco parentis. So we act as your supervisors, act as your parents when you're at school, and so you are limited there. But there is there's whole legal decisions about what kids can and cannot do. Tinker v. Des Moines during the Vietnam War, brother and sister wore a black armband in school, and the principal told them to take it off, and it went to the Supreme Court. They ruled they did have a right to protest the war in that way. Generally, courts have ruled that as long as you can maintain the environment for education, that protest, assembly, speech is okay. It's when it goes against the educational environment in the classroom that they will rule against students in that manner. But that is a time when you do not have, there are times in classes you don't have First Amendment rights.
Yeah, there a couple, one part of this question is are the rights absolute? And there's a couple of things that these are all from real cases, although if anybody wanted the citations, I can give it to you, but...
you can also look it up.
Yeah, that's true. One of the famous things about speech, a famous saying, which Oliver Wendell Holmes Jr., one of our more famous Supreme Court justices in history, said, do you have the right to yell fire in a crowded theater? And he was giving that as an example of you just can't have speech anywhere, anytime. One of the things about the First Amendment is these are key, critical human American individual rights. So when the courts look at claims of a violation of a First Amendment right, it's not like another case. They don't look at it from the point of view of, is A little bit better argument than B? What they look at it from the point of view is this government restriction or limitation on one of these rights compelling? Is it really, really necessary? The same case I just mentioned about yelling fire in a crowded theater established what was called the clear and present danger test. And basically what that meant is you can be trying to incite all kinds of things and trying to cause trouble with your speech and saying bad things about the government and all sorts of stuff. And what the U.S. Supreme Court said, they modified it a little bit, but it's still essentially the same rule, is nobody can stop you from doing that unless there's a clear and present danger of imminent violence. And so, you know, if you were in another part of the world, much of what you see on TV in the United States wouldn't make a lot of sense to you. You know, people protesting and yelling and screaming and saying all sorts of things and stuff. And the reason is, under the First Amendment, as in the United States Supreme Court decisions, the government simply can't stop you unless there's really a good reason. Now, violence, you know, and that sort of thing is a good reason. But just the possibility of violence won't work. So, you know, it's what in the law is called a compelling state interest test. Very, very difficult to meet.
You know, the speech it's not just what comes out of your mouth. The Supreme Court also has ruled that speech is money. That money is speech.
Right.
I did it backwards. That money is speech. Speech could be money too. I mean, but you're not getting paid for this, are you? No, I'm kidding.
Am I? No.
No, you're getting the RFs, the big virtue for doing this. But you know that using your dollar to do something is also free speech. And there's been some controversial cases, Buckley v. Vallejo, which determined that money was speech, but also Citizens United, which allows people who are not candidates to spend as much as they like on behalf of candidates, either in favor or against them. And that's become quite controversial in terms of whether or not it's knocking people out of political races because they can't raise that kind of money, or you're having a small number of people really determining who wins a race because they have the money to buy the literature or to put on the ads or whatever. So when you first do your research, what I would advise you to do is, you know, you may have a thought in your head right now, but do a little bit of research in terms of what this means over time, and maybe how it affects you or how it affects your future. Certainly, one of the things, and I'll give this a plug for those of you who will be 18 soon, one of the things that would be different in the state right now if 18 to 24-year-olds voted is college and your education. Public education would be quite different if 18 to 24-year-olds voted in terms of even your tuition. If people thought that demographic used their freedom of speech and their freedom of petition in a particular way, the outcome might be very different in terms of how the universities looked in the state. Because politicians do pay attention to those people who vote.
Yeah, I have, like I mentioned, some case examples of some things to think about. These are actually decisions that had to be made by judges. I'm not going to go through and give the reasoning or even the result, but just a snippet of the facts to give you something to think about how hard these can be. In one case, a Native American was denied unemployment benefits from the state because he used peyote at a Native American church. Now, peyote is
hallucinogenic.
It's a drug from a
It's a
plant.
drug. Mm-hmm.
The wrinkle in this is this wasn't just some Indian who was with drugs. He's from a tribe that has used peyote as a sacrament in their native church for over 500 years. And so this is a long ways from your drug dealer or drug user. This was used in a well-established religious sacrament, in a well-established, over 500-year-old religious view and church. So the challenge was made that you can't deny me unemployment benefits because of my exercise of religion. I do know how it came out, but I won't tell you. And another example is that's a religious free exercise of religion type of case. Another example that hopefully you have some feeling for is a band playing a concert really loudly, so loud that people in a rest home 2 blocks away can't sleep, and it's very bad for them. So the local government comes in and says, you can't have your band. And one question is a band speech? Is music? I will tell you the answer to that, yes. So the ordinance said, you can't play your band. The court said, no, they can't play their band that loudly. And so there's criteria. These are called time, place, and manner restrictions. And I wanted to specifically mention this because they're extremely common. Most of the time when you run into various limits and restrictions, they are time, place, and manner. There's 3 requirements before any governmental time, place, and manner restriction can be upheld. And the first one is incredibly important. This shows up in First Amendment law in basically every type of right, religion, speech, press. And that requirement is that the government regulation must be content neutral. And that's very, very important. What that means is they can't say the band can play that loud if they're playing classical music, but not if they're playing rap. They can only say any band that plays has to play at a certain level. The restrictions have to be narrowly tailored to serve significant government interests. So what's the government interest? Keeping the noise within a reasonable bounds. The original ordinance just prohibited bands, period. It was content neutral. Absolutely no band could play. No discrimination at all. But it was not narrowly tailored. And it must allow alternative or meaningful channels of communication. So, the original ordinance completely prohibiting bands failed 2 of the 3. When you see the lights on at the high school football stadium, the lights themselves don't have First Amendment rights, but everybody running around down there does. And if you're on a city government or a county government, these become extremely difficult.
I know. Let me interject something here because it did occur to me that this might be something of interest, and it does deal with the time, manner, and place. In 1999, there was a controversy in Amador Valley High School, and the controversy was this. The salutatorian was Muslim, and the valedictorian was Christian. And when they gave their speeches, the student, the valedictorian who was Christian, got up and gave what was to the administration a sermon, basically explaining that if you didn't live in this particular way, that you were going to go to hell. And it was quite fire and brimstone. The salutatorian, who was Muslim, started out his speech by saying, I want to thank my grandparents, my parents, and Allah. And then he went into an academic speech. The student who was Christian was told he could not give the sermon, basically, at graduation, and was told no. And it started a legal process that went all the way to the Supreme Court. And he was prevented from giving the sermon, and there was a reason why, and it had to do with time, manner, and place. Do you have any idea why he was told no?
Because he had a captive audience?
Because he had
Right.
a captive audience. That's exactly right, is that you had people that were there to see their children graduate, and they didn't have a choice of leaving if they didn't want to hear that. Well, there were, my son was in that graduating class, and there were media everywhere. There were trucks from every major outlet. There were newspaper people trying to interview the graduates as they were walking into the stadium. But it did, do you all know what the Supreme Court ruled? Since it was a captive audience, what do you think they said?
That you couldn't give the sermon?
That he could not. They ruled against him. But it was heavily funded by an outside source. It was popularly believed that this was a number of cases that different groups in different areas of the country were promoting. This was his faith, and he felt very strongly, believed very strongly in what he was saying. But when you purposely do something to bring something before a Supreme Court, it's called collusive.
Mm-hmm.
And so they were looking for someone who was willing to do this in order to bring the case. It was a test case, basically.
There's more of those than you would care to. Somewhat related to that, but to give you an idea of how tough they can be, one of the states, not California, but one of the states has on the grounds of its state capital a monument of the Ten Commandments. And it's been there since 1850. So there was a lawsuit to require them to remove the monument of the Ten Commandments. And the holding was they don't have to. This was a very split decision in the United States Supreme Court, but a very key part of the majority, such as it was, that allowed it is it was historical.
Now, to go on with that, one of the things that's coming out of another state, fairly close to that state, is that they also have some historical displays that are religious, and there are people who believe in Satan who would like to put something they believe historical next to it, and that's going to the court. So, it proves a couple things. One is this is a very complex issue, and depending on what region, some things are more of an issue in some areas of the country than others. But the other thing is that anybody can bring suit. Anybody can claim anything in the court of law. Whether they win or not is another story, but these are some of the interesting cases that you might come upon. Particularly if you look at current cases that are throughout the country, you will see that California often will rule differently than somebody in the Midwest, and some of it has to do with the culture in the area.
Yeah, another case, this is a religion case that, again, illustrates how difficult this can be, is a woman doctor refused to provide health services to a lesbian, and the doctor refused to do it on the grounds of her religious beliefs. Now, California has a law called the Unruh Act that prohibits discrimination on a number of grounds. Some of them you're very familiar with, race, religion, that sort of stuff. But one of the grounds is sexual orientation. Again, I could tell you how that came out, but I won't. But that will give you an idea. Now, if you're thinking about things like that, were there other doctors available who could have done the procedure? The answer in this case was yes, there were, but that, like I say, I'm not going to give you the ruling. When somebody's exercise of religion bumps into what are called laws of general applicability, which simply means a law that was enacted to deal with some kind of problem, is where it can become very difficult. Another case somewhat similar to what I was just talking about happened in California, where a couple who owned an apartment building, a small apartment building, refused to rent a unit to an unmarried couple. And they refused to do it because, in their view, under their religion, if you were living together and you weren't married, it was a sin. So that's the case that, what do you do if you're a court? Do you order them to let people live there? And thereby make the people on the property commit a sin? Or do you tell somebody who's not committing any unlawful or illegal act in any respect that, well, sorry, there's just certain places you can't rent, although anybody else could?
I think these stories illustrate how important it is for you to figure out what aspect that you're going to write. You can't hit everything, and when you write a good essay, you don't want to jumble it up with a list of things. What you want to do is concentrate on something that you can speak about because you feel passionate. Concentrate on something that maybe affects you personally or somebody that you know. Something you might have been interested in when you saw it on the news. Maybe something that you think was ruled in one way with which you don't agree. It doesn't have to be, I agree with all of this, or I disagree with all of this. We really want to know what you think about what you read. So the more that you could put yourself in this, in terms of how you think, the better off you'll be in terms of this essay. And again, of course, we would like it based on evidence. So these are just some of the interesting cases. If some of those pique your interest, they're certainly available when you do research, but it doesn't have to be any of that. And again, I think I would start with which of those freedoms do I find are most important, which of them maybe are not emphasized enough. Another thing that I think that has changed, at least in my lifetime, has been how we perceive the press. Right. And when you look at the press, we've often talked about it being something that keeps the government in check. Now we have such instant news that you can get something on Facebook and you don't know for 6 hours or so that it's untrue. And by then it's gone viral and it takes on a life of its own. People are not following the kind of rules that I think they taught in journalism school, and that is that you need to have a variety of sources and you're supposed to look at it in an unbiased way. And this is, I think, true really across the board in terms of popular news shows. Very often you're getting entertainment as opposed to news. And so as young people, what we hope that you do is that you get your news from a variety of sources. But as press, the ability for the press to check the government, to let the public know what's going on, has that diminished because of this new technology that we have? And we're tweeting constantly, and we're on Instagram, and now we're talking about putting body cameras on all the police officers so that you can get every viewpoint, and second guessing people because somebody's version of the truth hits the media before we know the entire story.
Yeah, tied into that in First Amendment law is what I'm about to mention is widely accepted but not universally accepted, and it goes up and down. But there has always been an argument that the key part of the First Amendment is what's called the marketplace of ideas. And you may have heard this saying that the cure for bad speech is more speech. The idea is simply that it is better to have ideas out there and other people talking about them and other ideas competing with them for the best ideas to ultimately develop from the discussion. That's a very, that pervades First Amendment law, but it's not universally accepted. I'll tell you, just some judges feel that the First Amendment rights are individual rights. And if you get too heavily into marketplace of idea analysis, then you're looking only at whether there are competing ideas and not the core right of an American to just speak. But it's very critical. It's more critical now with the internet and everything else for the reasons Cheryl mentioned. To find out the truth about anything, you probably have to read somewhere between 5 and 15 different versions of it. There's so much information, and there's so much capability now of people to just put out there anything without the journalistic standards.
And I think the one thing that we haven't mentioned is freedom to assemble. And I think that, I don't know, do any of you take AP US History? Okay, so you know that part of the controversy is this new test. and whether or not it has somehow changed what we've taught. And so the books are the same, the curriculum is the same, it's really a strategy, but there are some places where they have talked about eliminating AP from the curriculum. One place was Colorado, and there were 2 schools that participated in marches. In the first one, the school tried to prevent the students from marching. They couldn't because it was a critical mass. They left school. Of course, they were subject to whatever consequences were available to the administrators for leaving school during school time. But in the second school, instead of trying to prevent the march, the administrators and the security on campus marched with the kids to keep them safe. And so there's an example of how a public school might view your personal right to assembly at your age. And I don't know whether you've ever had a situation at your school where kids have gone out to protest. I certainly have at the schools that I've been at. But a lot of that has to do with the way your administrators might perceive your rights. And how important is that? What would cause you to walk out of school? I'm not sure for me it would be the AP test, but and I teach it, and I'm not sure that's what it would be.
Well, another thing in First Amendment law to give some thought about is what's called the doctrine of prior restraint, which is the legalistic way of saying somebody in the government tells you you can't say something before you say it.
No, stop.
Prior restraints are not favored. In fact, they're disfavored big time. But there's a couple of different ways, and one of them is the court's use of injunctions. And an injunction is a court order that you cannot do something or you must do something, and if you do it or don't do it, then you go to jail. And there's a long history in the world of prior restraints, because the idea is if I don't want another idea to compete against mine, the easiest way is not allow the other idea to ever be said. So I can cook up many different ways to prevent them from saying things. One case in California was a woman who lived across the street from a bar, and she was kind of a troublemaker. From the bar's point of view, she was the ultimate troublemaker. She used to film everybody going in and out of the bar, tell people they were drunks and worse. She accused the bar of being a child pornography shop, of running a methamphetamine factory and all sorts of things. Almost none of this was true. Some of the drunk part was true, but so the bar went in and they got an injunction against her. And the injunction said, "Dear lady," by the way, she did this standing in her own front yard, "you can't say these things about the bar. You can't say that they're a methamphetamine factory because that's not true, and it's now been proven in court not true." So here's the dilemma that the judges had to deal with, which is once you've been to court and it's been determined in a court proceeding that what you said is falsity is not protected by the First Amendment, can they then enjoin you so you can't say it in the future? And the reason that's a big legal battle is things change. So again, I'm not going to tell you how that came out, but that was a very close decision and very much debated. The reason is an injunction is a prior restraint. It told her you cannot use these words. Very, very unpopular in American constitutional law.
So how much time do we have?
We have about 10 minutes, but 5, I think, for questions at the end.
Okay. Do you have any questions right now?
Any question?
No? Okay. So we've gone over Establishment Clause. We've gone over the Free Exercise Clause. We've talked about assembly. Do you have any assembly cases there?
Actually, yeah.
Okay.
The Ku Klux Klan leader, this is not that old of a case, by the way. The Ku Klux Klan leader, with a few of his strange buddies, was in front of a government building, and he kept railing about evil government and how there needed to be violence directed against the government, and there should be all kinds of horrible things done to the government. Well, the government didn't like this, so they had him arrested, and he was convicted of a crime of inciting violence. So it went to the U.S. Supreme Court, where his argument was, so I don't like the government, and I think they ought to be shot and blown up. But I didn't have any guns, and nobody lets me have a tank. So the U.S. Supreme Court, I will tell you the decision, reversed the conviction. And this is actually the standard for what's called inciting unlawful or illegal activity. The government must show that the advocacy is directed to producing imminent lawlessness and is likely to immediately produce the lawlessness. Now, why he got convicted is him and his little group had no chance of doing anything. They were just out there yelling and making noise and threatening. But there was no chance of them actually doing anything. And this is an example of how truly unique the First Amendment is in the world. This is probably the only place in the world that could happen. Now, does it matter that this was a Ku Klux Klan member as opposed to, say, an extreme socialist or communist? No. Why? Because they look at this from a content neutrality. There's nothing in there about, we don't like the Ku Klux Klan, we think they're wrong, or anything like that. Any more than any U.S. Supreme Court opinion says we like Catholics, but we don't like Buddhists. They don't talk like that because it is irrelevant. The content is irrelevant. The only relevancy is, was the threat such that the government needed to take the action? Now, if he actually had something, if he was throwing a Molotov cocktail at the mayor, this never would have made it to the United States Supreme Court. It probably wouldn't have made it to any appellate court, and he'd probably still be in jail.
I see you have a question.
So you said they're content neutral, but
Right.
does this apply to like hate crimes?
Okay,
Is that separate?
that's a really interesting thing. I'm going to repeat his question because I'm not sure he wants to know that it needs. He mentioned that it was content neutral, but does this apply to hate crimes?
Actually, it doesn't apply to hate crimes because the theory behind the increased punishment for hate crime is that the motivation of the crime, the act, not the speech or anything, makes the harm and the antisocial nature of the act more horrendous. If I beat you up because we got in a fight, that's one thing. That's assault. I can do time in jail for that or even prison. If I beat you up because of your skin color, I'll do more time in jail. The latter is a hate crime. The first is just a good old classic crime.
Well, and with the situation in North Carolina where the I think it was 3 Muslim people were shot, there will be a question about whether that's a hate crime. I mean, what we've heard on the news, we certainly can surmise that perhaps it was, but we don't know all the details, and there'll be some determination in court as to whether or not that's considered a hate crime.
Right.
I'm not sure whether that's been adjudicated yet.
Now, the whole issue of hate crimes, hate crimes are fairly new in legislation and in law, is a very difficult one. They were only barely allowed to stand by the courts, and they were allowed on the grounds I just said, that it's punishment for the motivation of the act.
Mm-hmm.
There's obvious tough questions.
I'm going to mention one other thing, and I'll tell you a short story about this, is that oftentimes when you talk to people about, Congress will make no law to abridge the right to petition, people think it's written, maybe a letter
Right.
or a list of names. But petition is any time you go to the government and ask for something. It could be in a Congress member's office. It could be at the podium at a school board. Have any of you ever gone to a school board or a city council meeting? Okay, anytime somebody goes to the podium, and you might see it on TV, and asks for something, they're petitioning the government. So I was sitting with someone who was a developer. I was a council member at the time, and we were talking about just what I said, that only 3% of the people knew the 5 freedoms. The one he missed was petition, which is what he was doing at the table. He was actually petitioning me for something that he needed from the city, and that was the one he missed. So 2 or 3 months later, we're at a joint meeting with the school board, talking about a development and impact fees. Those are things that probably are uninteresting to most people. And he then brings this up. The room is full of lawyers. And he said, and I was embarrassed because I missed this one. Do you know what they missed? The same one. And that's what they were doing. They were petitioning the government. And I think that, you know, one of the things that's great about having an essay contest like this is it not only broadens your scope of understanding in terms of what this means and what it'll mean to you as adults, but it also helps publicize this for other people. This really is what our democracy is based on. If we don't have freedom of speech, how do we tell the government what we want? How do we tell them when we don't want it, if we don't have this right? If I can't talk to whoever I would like to talk to when I want to talk to them in terms of freedom of assembly, how do I know whether there's people who believe the same way I do or differently? There was a law in Pleasanton where if you rented a park area and you had outside people that were from outside Pleasanton that came in, you were supposed to give a list of these guests to the city. When I became a council member, I almost had a heart attack. That's illegal. You can't do that. It's unconstitutional. And they'd been doing it for years. If you weren't a Pleasanton resident, you were supposed to give them a list. I said, you can't ask them that. You know, and this comes from a case from the NAACP in the early part of the 20th century. But you don't have to give over a list of people with whom you assemble.
Yeah, or associate.
Or associate.
In petitioning for grievances, the First Amendment says to petition the government for redress of grievances. That includes going to court. If you brought a lawsuit and you were asking the courts to hold unconstitutional some law or to enjoin the president or somebody, then obviously you have some kind of grievance, and that's in the courts that's clearly involving the government. But if you just sue your neighbor because their cat scratched you all up, is that petitioning, going to court? Is that petitioning for redress of grievances? Or, in other words, do the grievances have to be grievances against the government? I do know the answer, but I'm not telling you.
But we have a right now to assemble.
We do certainly
Yes.
have a right to assembly.
Yes.
And that's what we're exercising.
That's exactly
That's
right. That's exactly right. Do you all have any questions? You haven't had a chance to read this, but one of the things I would tell you when you go over this is to make sure that you follow the directions. I think that's the most important thing when you apply to anything, is make sure you follow directions. But also, having said that, there's occasions when things are interpreted different ways,
Right.
as we've given you a number of illustrations of that tonight. So if you have a question, make sure that you ask before you turn it in. Obviously, you know, all the kinds of things that your teachers tell you about making sure that it's written in, you know, exact, effective English, that you're using all the grammar and the spelling that you need to do to write a good, effective essay. But again, I'm going to tell you again that we're very interested in hearing about what you have to say about what you've read based on evidence. We want to hear what the conclusions you come to. It's not a judgment about whether I agree with you
Right.
or John agrees with you. It's whether or not you base it on evidence and that you have a strong opinion.
Just wanted to come forward and thank, first of all, our panelists are amazing people. I've served for years in the government with Cheryl Kallio, and I didn't know you were an amazing teacher.
Oh,
and
bless your
history
heart.
for
Thank you.
35
Thank
years.
you.
I
I'm
just
going-
knew
I am
she
going
was
to-
really an amazing councilwoman. And John Murphy, of course, his background with respect to is impeccable, with having served as senior attorney for the Supreme Court of California and the Veterans Council in Washington, D.C. And I'm only touching a little bit of it. And those of you in sports, also a head of soccer all over California. So, you have a mixed life and you see these in many different areas, but it's really important that these students that were here today, we especially appreciate it because they know that they have freedom shrines at the school on which this is based. And that's after World War II, when America's documents were crossing America to thank everyone for the freedoms that we had in 1947 and 48. Those were put together into permanent photographs that are in our archives in Washington, D.C., and now these are in 13 places, and we're putting 2 more in the schools right now.
Great.
So if you can't find a freedom shrine to base it on, you have the right to have one of our books. We'd love to have it. If you couldn't come tonight, we want you to have one, and to be able to get out and see those and see what they mean. So you've made it. Your examples are amazing, even though I can't tell you what I really think because I have to mimic what you're saying here. But Donna Kerger, I want to thank her especially for getting out to the schools and telling everyone about this and to set this up. So if you have questions, you're going to go to our website, I hope. It's really easy because our website person is here, our website master. It's srvexchangeclub.org, and you get your application there, you get the rules there, you see the freedom shrines, and you can find phone numbers to call. But we can't thank our panelists enough for just covering, as you said how many volumes? 12 volumes that we would have to cover tonight. And you've given them a lot to think about and a way to frame the essay. So thank you for being our guest.
Oh, thank you.
Yeah.